Assalamu alaikum. Good evening, ladies and gentlemen, and welcome back to our program in relation to criminal law, where we aim to raise awareness and to provide clear guidance on the criminal justice system, helping our viewers better understand their legal rights, their responsibilities, and in particular, the importance of early legal advice when dealing with the police and or the courts. Throughout this series, we'll cover a range of important criminal law topics, breaking down legal issues in a way that is clear, practical, and accessible to the public. Tonight, we turn to a topic that is both sensitive and extremely important, and that is domestic abuse and domestic incidents. This is a subject we have specifically chosen to address because it is an issue that affects families and communities, and including, sadly, the local community here in the London Borough of Tower Hamlets. This is a subject we have received repeated requests to discuss this particular area, not only because of the growing concerns around domestic related allegations, but because there remains significant misunderstandings around what the law actually says, what happens when police are involved, and what rights people have. Domestic abuse is not simply a private family matter, it is a legal issue, often a criminal case, and one that can have profound legal ramifications for complainants, for those accused, and for entire families. Tonight, our aim is to inform, to clarify, and to ensure that our viewers understand both the law and the importance of getting proper legal advice at the earliest possible stage. I'm joined this evening by three experienced criminal defence solicitors who will help guide us through this discussion. Thank you all for joining us. Please, if you can help introduce yourself and your role.
Yes, good evening. My name is Mark Berman. I'm a senior criminal solicitor. I've been advising clients in the police station and in court since 1996, and I specialise in criminal law.
And yourself, sir?
I'm John Abedin, and I'm from Lord Sullivan Solicitor. I'm a principal solicitor, Lord Sullivan. Thank you.
And yourself, sir?
Sheikh Suleiman, solicitor. I practice criminal law. I attend police stations, courts in and around London, in the Tower Hamlets, and also for central London as well. But Charing Cross Police Station, Bethnal Green Police Station. I was at Bishopsgate actually last night. So I advise suspects on who are accused of domestic related incidents.
Well, let's begin with the basics, and thank you all for that. When we use the term domestic incident, what exactly does that mean in law, Mr. Berman?
So a domestic incident within the parameters of criminal law normally means an incident that is between either a husband and wife, boyfriend and girlfriend, or even within family members. So anything within a kind of domestic setting is under the umbrella of domestic as far as the police are involved.
And I think that's an important starting point because many people immediately assume domestic abuse means physical violence, and that's not always the case. Do domestic incidents always involve serious violence, or can the law apply more broadly? Solomon, if you could answer that.
In law, abuse can include, but is not limited to, violence. It could be threatening behaviour. Abuse may consist of a single incident, or it could be sort of a pattern of behaviour. I think that's more precisely put. Is sometimes it could be sort of a single incident where there has been violence. However, it could be a more sort of pattern in behaviour in a way where it's escalating to violence through comments being made, sort of threats, empty threats, but leading to the effect on the person who is being subject to this abuse or this behaviour. Importantly, the person who is being abused may not immediately recognize that they are being abused, and sometimes it's things that we don't appreciate might not include just violence in itself. For example, controlling finances or controlling someone's behavior, telling them not to talk to certain people, isolating them, telling them not to keeping to a check on people, how they spend their money, who they talk to, where they go, and potentially it could be the comments being made, let's say appearance or the sort of their behavior. It might be just continuous negative energy or comments, which may cause psychological or emotional abuse. It could be manipulation. So no, it's not limited to violence.
Well, that naturally raises an important question. Why do matters inside the home often involve the police, if you can?
Okay. What it is, thank you for asking this question. What it is, normally domestic abuse is defined differently in our society. আমি যদি বলি বাংলাতে, আমরা সোসাইটি, বেঙ্গলি কমিউনিটি সাধারণত ঘরের ভিতরে যে একটু শাউটিং হয়, বাচ্চাদেরকে কন্ট্রোলিং করা হয়, এগুলো ভালোর জন্য, অনেক সময় ভালোর জন্য হয়, কিন্তু ল এগুলো ডিফাইন করে না। ল সাধারণত আমরা এই প্রোগ্রামটা অ্যাওয়ারনেস, এই জন্য অ্যাওয়ারনেস প্রোগ্রাম দেওয়া উচিত আমাদের সমাজে। যে জিনিসগুলো মানে ক্রাইম হয় এগুলো আমরা অনেক সময় জানি না, যে ক্রাইম যে হয় এটা আমরা অনেক সময় জানি না। যেমন ছেলেমেয়েদেরকে দেশে অনেক সময় দেখা যায় তার ভালোর জন্য, ফর দেয়ার গুড ফিউচার, মা বাবা, বড় ভাই, বড় বোন এরা অনেক সময় কন্ট্রোল করতে চায়। যেমন তুমি বাইরে যাই না লেট নাইট, অথবা তুমি সোশ্যাল মিডিয়াতে খুব অ্যাক্টিভিটিস করবে না। অনেক সময় ইসলামিক স্টাডি, বলবো না ইসলামিক স্টাডি, অনেক সময় স্টাডি, এবং এগুলো বলা হয় ভালোর জন্য, কিন্তু অনেক সময় আমরা হয়তো জানি না বা জানতাম না, বা এখনও যা হয়তো আমরা অনেকে জানি না, এইগুলোর জন্য কিন্তু ক্রাইম হয়ে যায়, অ্যাসল্ট হয়ে যায়। যেমন অ্যাসল্ট হইতে পারে আপনার শাউটিং, ফিজিক্যাল টাচ ছাড়াও, আমি হাত ছাড়াও অনেক সময় অ্যাসল্ট হয়ে যায়, সোয়ারিং করলে অ্যাসল্ট হয়ে যায়। যেমন আপনি একটা ছেলেকে বা মেয়েকে আপনি পয়সা দিবেন না, সে হয়তো বা খারাপ পথে পয়সাটা খরচ করবে, কিন্তু এটাও কন্ট্রোলিং হয়ে যায়। সুতরাং আমরা যদি অ্যাওয়ারনেস প্রোগ্রামটা সবসময় করি, আমরা বা যে কোনো ল ডিপার্টমেন্টে প্রোগ্রাম করি, তাহলে অনেক উপকার আসবে সমাজে। যেমন কি what's the question?
The question is, when do police get involved in
Police can get involved without complaining. Domestic abuse-টা হয়েছে, এটা একটা ন্যাশনাল একটা ক্রাইম হয়ে গেছে, এবং অনেক সময় ইচ্ছা যদি কমপ্লেইনেন্ট ছাড়াও অনেক সময় পুলিশ ইনভলভ হইতে পারে। ডোমেস্টিক হইতে পারে বাবার লগে, মার লগে, ছেলে মেয়ে, ওয়াইফ, এগুলো হইতে পারে। তাদের বিহেভিয়ার ডেফিনেশন করবে, বিহেভিয়ারটা কোন ধরনের বিহেভিয়ার। ফিজিক্যাল টাচ ছাড়াও বিহেভিয়ার যারা আর্গুমেন্টিং ফ্যাক্টর হয়, থ্রেটেনিং হয়, অথবা অনেক সময় দেখা যায় আমরা যে স্পিডিং করে এটা অ্যাসল্ট হয়ে যায়। এটা ডিপেন্ড করে তার ইন্টেনশন কী চাইতেছে। অনেক পুলিশের কাছে, তারা পুলিশে যদি জানে there are something going on in the family, police can come in, police can get involved without complaining or without any complainant. So যার জন্য ভেরি সিরিয়াস ম্যাটার আমরা দেখছি অনেক সময় যে পুলিশ যখন ইনভলভ হয়ে যায়, তখন মা বাবা অথবা ফ্যামিলির কেউ ইচ্ছা করলেও যেগুলো পুলিশের কাছে কেসটা আনা যায় না, রিভার্স করা যায় না, যদিও তাদের ইন্টেনশন ছিল না এরা, কিন্তু পুলিশে অনেক সময় কেসটা ছাড়বে না। সিপিএসের পাড়ায় সিপিএস মনে করে দেয়ার আর সাম এভিডেন্স, ফুটেজ এভিডেন্স, অথবা নেইবার নেক্সট ডোর তারা উইটনেস দিচ্ছে, তখন ছেলে বিরুদ্ধে বাবাও ও ইচ্ছা করলেও কেসটা মানে রিটার্ন আনতে পারে না, পুলিশ নিয়ে যায়। সুতরাং আমাদের মনে হয় যে we have to be very aware of this situation. Thank you.
Thank you. Now, why do these situations so frequently move beyond the family home and into the criminal justice system? Mark, if you may.
So when the police normally attend an incident, there can be lots of different reasons they've attended. It could have been that the alleged victim themselves have called the police, perhaps neighbours have called the police. And on attending, the police have to make a decision. The decision is normally twofold. The first one is whether they feel there's sufficient evidence to pursue some type of allegation. And the second one is whether they need to remove one of the parties from the location for fear of further repercussions. So it could be that the police attend a domestic allegation and don't believe that there has been an allegation or has been an offence that's taken place, but make the decision to remove one of the parties from the scene. So that's one possibility. And the other possibility and the other thought is that the police tend to have what they call a positive arrest policy. What that means is that they would rather take one person out of the situation and investigate so as just to calm things down.
Right.
Because within a family unit, in a family setting or a domestic setting, emotions are often quite high. So the police are thinking if they remove someone out the scene, they can diffuse the situation and then they can investigate further.
Okay, very interesting. So once the police are called, things can often move very quickly once the police are involved. And what usually happens when police officers attend a domestic argument? Someone, if you can answer that.
Usually, it's a neighbour who's heard some shouting, or it's what we call an abandoned 999 call. I mean, it's happened in practice, or sometimes, I mean, I've had cases where I've dealt with where the complainant who has called the police to have someone else removed, police have attended the address, done intel checks. They have on their police national computer, they have the information that they have access to, certain history about a certain a person, and has revealed that they're actually subject to non-molestation order or restraining order. And although it was initially the client who's called the police to the address because their partners or their cousin or their son is destroying, damaging property, once the police have arrived at the location, they've done their checks and said, well, you're subject to conditions not to contact this person,
Right.
or not to be in a certain place, and you're in breach of that, so we're going to take you, not the person who you've made the allegation to. It all depends, because that's obviously what Mr. Burma was saying, where things go beyond your control once the police have got involved, because there's certain factors that come into play that may not have occurred to you when you have called the police or why the police have attended. A lot of the time it is abandoned police call, when someone's called 999 and then put the phone down straight away without explaining what's happened. But because a call's been made, the police, they're under a duty, obligation to attend the address. And when they have attended the address, there's this misconception where they think that the police are not allowed in the address. They're mistaken. If they're investigating or they have concerns about someone's being injured or someone's at risk, they will gain entry to the property. A couple of cases I've dealt with where an allegation has been made about one thing, and then as soon as the police have come, it's a completely separate allegation. Someone has called the police against a client I represented at Bishopsgate, saying that they have threatened to stab their partner. But on arrival, it was a simple criminal damage. She's gone out and she's damaged the vehicle belonging to her partner. Similar situation I'm just reading on. I had a Bengali client. I appreciate that a lot of our viewers Bengali, and they might find this one a little bit funny, where my client, he came home and he made a threat to harm his children and his wife, and his own brother has actually called the police on behalf of his wife, and the wife then, initially when they came, just because of the threat, she then sort of had that invitation to report to the police that 2 weeks ago, prior to this incident, he grabbed what we call a da, and he chased her around the house with the da, and the police, even if it's an allegation from 2 weeks ago, or even 2 years ago, or even I've had cases where it's 13 years ago. Through the course of 13 years, I've been with this person.
Right.
A domestic sort of, it's escalated to the point where now it's being reported. So you have to be very careful because it's not just immediate what's happened. It's throughout your whole entire relationship with this person that might be concerning or alarming. That objectively someone might think, well, there's something to investigate here, and ultimately, I think that's what it is.
Well, that's very interesting, and thank you for that. So this leads me on to my next question. Are the police there trying to calm the situation down, or are they already gathering evidence? Mr. Berman, if you can answer that.
From the moment the police attend the station, most officers these days have what we call body-worn cameras, which are little mini cameras recording everything they see. So, in theory, as soon as they attend, they are recording, and that will be classed as evidence. Also, the evidence that they would be obtaining might be from the 999 calls from the victim or alleged victim or neighbours. Sometimes quite compelling evidence is when a 999 call is made by a victim and they can hear the complainant or the suspect in the background shouting, which is obviously all recorded. So the evidence gathering starts at quite an early stage, and then obviously it's for the police to investigate further. If there is some cogent evidence, what the police will then do is arrest the suspect, take them to a police station, and that's when the formal police station process starts, which we'll talk about in a moment.
Right, okay, thank you for that. A common concern people have is, do the police have to arrest someone if they think some crime has been committed? I know you touched upon that earlier, if you can just elaborate on that.
Yes, the
question is, do police have to arrest someone when an allegation has been made?
Yes. Give me a second.
And also my question is, can someone still be arrested even if the person says they do not want to make a complaint?
I can step in here because it's quite an interesting area of law, and it's an area of law that's evolving. But just following on from what I mentioned before, the police and the one have a positive arrest policy, so they will tend to arrest if they're not sure. But if the alleged victim doesn't wish to proceed, they can still proceed without a victim statement.
Oh yes, okay.
That's not necessarily required. So it's an evolving area, so it's worth just jumping in at that point.
Okay.
Yes.
So if you can just add, let's say if someone is arrested and they make a statement, can they withdraw that statement later on?
Okay, it's a good question. I don't think so. They cannot. If someone made a complaint or against someone and they want to withdraw, it's up to police now. If the matter goes to CPS and the charge, they cannot because he will be who complained, he will be or she will be the witness.
Right.
So even though they wanted to decide to do the case for safety or family reunion or something, sometimes they cannot. Sometimes they can. It depends if the case is not charged. So like the case is not charged, CPS hasn't charged, and the police is still investigation. The police can drop the case. Sometimes they don't drop if there is a lot of evidence. They cannot drop the case and they don't want to withdraw the case. Okay. But this is a different situation.
Yes, yes.
One thing I can add on that, when people have on bail, if somebody committed crime, police arrest, and then bail condition. Sometimes we have seen, most of the cases in the families, when the suspect come out from the police station and emotionally মনে করে যে আচ্ছা পুলিশও আছে কেস পুলিশটা হোক আর আমরা মিলে যাই সাথে সাথে এবং পুলিশে কিন্তু বেল কন্ডিশন দিয়ে দেয় যে কন্ডিশনটা ব্রিচ হয়ে যায় যদিও মানে দেখা যায় যে তারা নেগোসিয়েশন করে যোগাযোগ করে এবং যোগাযোগ করলে অটোমেটিকলি বেল কন্ডিশন ব্রিচ হয়ে যায় তারপরে আবার রিঅ্যারেস্ট হয়ে যায় এই জিনিসটা অনেক সময় আমরা জানি না যে ইনডাইরেক্টলি পুলিশ জানে যে হ্যাঁ একটা লোক ধরেন হয়তো এক্সক্লুশন হয়েছে ফ্যামিলি হোম থেকে সে আবার করে আসতে বলতেছে পুলিশ দেখে নাই কিন্তু যদি উইটনেস থাকে বা সামহাউ পুলিশ জানতে পারে সে কিন্তু অ্যারেস্ট হয়ে যায় এটা কিন্তু আমরা জানি না তারপরে যে জিনিসটা হইলো যেমন যে লটা আসছিল যে প্রিভিয়াসলি আমি বলি নাই যে ডোমেস্টিক অ্যাবিউজের যে লটা হইলো সেটা হলো অ্যাবিউজ অ্যাক্ট 2021 এইটাতে ডিফাইন করছে আর কি যে ডোমেস্টিক অ্যাবিউজটা কীভাবে হয়, মানে কি কন্ট্রোল করলে কি বিহেভিয়ার হলে যে ডোমেস্টিক এটা পড়ে। তারপরে এটাতে সিরিয়াস ক্রাইম এটা আবার ডিফাইন করছে সিরিয়াস ক্রাইম অ্যাক্ট 2015-এ বলছে যে কন্ট্রোলিং করলে একটা লোককে আইসোলেশন করলে অথবা তারা মনিটর করলে ফাইন্যান্সিয়াল কন্ট্রোল কীভাবে এগুলা ক্রাইমটা ডিফাইন করে এগুলা ডোমেস্টিক অ্যাবিউজের সেকশনে বলে এই লতে বলে দিছে আর কি। সো পরিশেষে আমি এটাই বলবো এই কোয়েকশনে যে আমরা এই কন্ট্রোলিং করার সময় আমরা যেন বি কেয়ারফুল থাকি যে মানে কীভাবে কন্ট্রোলিং করতেছি এটা যেন ক্রাইমে আবার না পড়ে এটা সচেতন হওয়ার প্রয়োজন আমাদের এই সমাজে। এটা যেহেতু এটা অ্যাওয়ারনেস প্রোগ্রাম এটা আমাদের মানে বারবার বলতে হবে, প্রত্যেকটা জিনিসের স্টেপ নেওয়ার সময় মানে চিন্তা করতে হবে যে আমরা কী করতেছি এটা আইনে পড়ে কিনা, এটা চিন্তা করার অনেক সব প্রয়োজন। তারপরে যে জিনিসটা আমাদের একটা হ্যাবিট আছে যেগুলা মা থেকে মাসির দরদ বেশি, এটা বাংলার কথা আছে যে খারাপ দরদ বেশি মার থেকে। যেমন অনেক সময় দেখা যায় আমাদের বিহেভিয়ারে অনেক সময় সোশ্যাল ওয়ার্কার ইনভলভ হয়ে যায় ফ্যামিলিতে। সোশ্যাল ওয়ার্কার এই দেশে প্রায় লোকে জানে যে বাচ্চারা যদি তাকে বাচ্চাদেরকে অ্যাবিউজ করা যদি হয় অথবা ফ্যামিলিতে প্রবলেম হয়, মা বাবার প্রবলেম হয়, তাহলে বাচ্চাটা যদি তাকে সোশ্যাল ওয়ার্কার হয়ে যায় ফর সেফগার্ডিং পারপাস। সোশ্যাল ওয়ার্কার ধরে করে কমিউনিটি, এটা আমরা দেখি অনেক সময় যে সোশ্যাল ওয়ার্কার যদি আমাদের কমিউনিটির লোক থাকে, বাঙালি থাকে, তাহলে আমাদের বাঙালি ফ্যামিলি কী করে মনে করছে আমাদের বাঙালি ভাই বোনটা আসছে যা খুলে বলে দিই সব কিছু আমাদের কী হয়ে গেছে। সোশ্যাল ওয়ার্কার কিন্তু তাদের খালাতো ভাই না বোন না, এটা উচিত। সোশ্যাল ওয়ার্কার হিজ ওয়ার্কার ইজ আন্ডার দ্য গভর্নমেন্ট, স্টেটের সোশ্যাল ওয়ার্কার এটা প্রোটেকশনের জন্য কাজ করে। এটা আমাদের আত্মীয়তার জন্য বাঙালি হোক ইংলিশ হোক যে নেশন হোক সোশ্যাল ওয়ার্কারের সব কিছু বলা যাবে না।
Because they're working for the child's best interest.
Child best interest. এবং স্টেটের প্রোটেকশনের অনেক নিয়ম আছে। অনেক সময় দেখা যায় সহজভাবে আমাদের যারা কমিউনিটির লোক আছে সোশ্যাল ওয়ার্কার সব বলে দেয়, তারপরে বাচ্চাগুলো নিয়ে যায়। মানে বোঝা যায় যে বললাম মাটা কি চাষির দরদ বেশি, খালার দরদ বেশি, সোশ্যাল ওয়ার্কার বাচ্চা নিয়ে যায়, অথচ পরে মানে বাচ্চাদেরকে আনা অনেক কষ্ট হয়ে যায়। সুতরাং এই ব্যাপারে আমাদের অনেক সজাগ থাকতে হবে।
Thank you. Many people misunderstand that point, so grateful to you for that. So it is important to be clear that these cases are often evidence-led. Now, Mr. Berman, what are police actually looking for when they arrive at a scene where perhaps maybe an incident has occurred?
So the two objectives, one is to safeguard the position, safeguard all parties, and the second point is to uncover any evidence that may be appropriate for the offence. If there's anything on site or on scene, they will retrieve that. So if the allegation involves, for example, criminal damage, if something has been broken, they'll take photographs of that item. If the case involves an assault and if the victim has been injured and there is, for example, blood at the scene, they will take photographs, take samples, etc. So they're the two main things they'll be looking for, and they'll also be looking to obviously take, if appropriate, take the person into custody for further questioning to obtain their version of events.
Right.
Yeah.
Thank you. And things like body-worn footage, VRI, neighbours, digital messages become central evidence. Would you agree with that, Solomon?
I will. What I would say is I just want to touch upon what my principal has said regarding whether the police always arrest someone. Arrest, I would say, is whether in the context of things, when the police have arrived at a location, the first thing they're looking to do is prevent further harm. That's one of their main objectives. Secondary to that is securing evidence. So touching upon what else can be used as evidence. It could be circumstantial, or like I said, it could be sort of a context of how someone has made a statement in an emotional, being in an emotional state. They might change what they say later, but for example, if you're angry and you're talking and then you've calmed down, you might change how you feel about a certain person. Time heals
Or wounds,
Or wounds.
as they say.
They're protecting vulnerable persons. So when my principal has mentioned when children are involved, especially that, I mean, as soon as they've arrived on scene, they're looking to see if any offences have been committed in the presence of children. Domestic violence, I want to emphasise, is a criminal offence is a criminal offence, whether
Absolutely.
it's criminal damage, assault, sort of any sort of theft. Domestic makes it an aggravating factor. Does that make sense?
Yes,
It
yes.
makes this situation sort of
A little bit more tricky, would you say?
more serious.
More serious,
because
okay.
because it's been committed in where you're sort of got in effectively a position of trust.
Right, okay.
They're seeing
Yes.
that it's much more serious than I would say that if you're just damaging something on the street, criminal damage, it's not. But if you're breaking something after an argument, breaking someone else's phone, because of the domestic nature of your relationship, it's much more serious. Sorry, I just want to get on to the questions regarding the evidence. What was it? There's a Latin phrase that I wanted to introduce. It's usually when it comes to hearsay, is secondary statement it's not allowed in court. When you've heard, let's say, rumours, speaking sometimes without evidence, or I heard this about this person, and you want to use it because you colour the other person. For example, someone I know someone's made a false allegation, but you can't really prove it. But
It's inadmissible, effectively.
it's inadmissible. But the Latin phrase, I think it's res gestae.
Register.
Register. It's a statement made during or immediately after an incident where the person is still emotional and reacting to naturally what happened. Police take them statements very seriously,
Right.
and especially the prosecution, they will rely on that.
Heavily,
They
yes.
would. I mean, it's an exception to the
The
rule.
rule exclusion, yes.
Yeah. Body-worn footage, medical evidence, photos, neighbours, telephone messages. They seize your phone. They ask for your PIN. For the priority. I mean, even yesterday at Bishopsgate, my client had 2 phones. He relies on his phone to work. He's explaining to the police, "I need my phone for work. I'm a driver. I need my phone for." They said, "No, there's evidence on your phone. We're going to keep it. We're going to seize it." And they usually serve a notice to say, "Well, if you don't provide your PIN, that could constitute another offence."
Yes.
Also, another very, very important thing, this is why you should always have a solicitor before interview
Thank you.
in domestic cases.
Yes.
Because when they're asking you questions, they're looking for inconsistencies. Your evidence, when you're answering questions, sometimes you might say things that are misunderstood. And a lot of us, I mean, you're talking, especially if you're Bengali, you're saying something that's out of context.
Well,
and
you're an emotional stage. So
emotional stage. So they might rely on your inconsistencies. It's evidence-led prosecution. It's not
Yes.
private matter anymore.
Right, and yes, because of the emotional state that you're in at the time, you might say something that you don't mean, and then they might think there's a propensity to do that again and again. Right, thank you all for that. We're going to turn on to the offences as soon as we come back very shortly, and thank you. We'll be back shortly. Thank you for joining us once again. In our program where we're talking about domestic incidents and domestic abuse, we're going to start off now by going through some of the offences that are involved in domestic disputes, starting with assault. What legally counts as an assault? Mr. Mark?
So assaults can be really quite wide and varied. They can refer simply just to words or threats, which amounts to what we call a battery offence, which is the lowest level of assault. And then there's a spectrum of assaults which really depend on the level of injury that's received by a victim. So we have a common assault, which is where assaults start with, which is the next one up, which is a basic assault so literally grabbing somebody by the lapels or grabbing them by the shoulders, or any unlawful contact is actually considered an assault, which is a common assault. The next one up, so to speak, is what we call actual bodily harm, termed ABH, which is normally when there's a laceration, which means a cut, a superficial cut or some bruising. And then the next level up, if you like, is called a GBH, a grievous bodily harm, again coined GBH, which is more serious injuries. So we're talking broken bones, we're talking deep lacerations, deep cuts, etc. And then the next one up would be along the lines of attempted murder, etc. So the GBH is very serious. It could be life-changing, life-threatening injuries, but they're the different spectrum if we're just looking at assaults, strictly speaking.
Thank you. Solomon, can someone simply be arrested for pushing and grabbing someone?
Yes.
I understand you deal with a lot of assaults, actual body harm, grievous body harm. If you could just give us...
Just to top up on what Mr. Burnham has said regarding the assault. Assault lies in fear, causing someone to fear. I think the question really is whether a reasonable person would feel threatened by the act or actions that has been is done in the heat of the moment, given the context, especially in domestic setting. Battery lies in the act itself, unlawful application, and that's what Mr. Burnham was saying, grabbing someone, something like this. It could be something in a moment of anger, especially in domestic settings. It's always something of anger. But like I said, these are criminal offences. It's just because it's domestic, you're doing it to someone who you're personally connected to, which is family, father, mother. I mean, I've had clients who've done it to their mother, in a sense. So it's really wild out there. Injury is not required. I think that's very important, because some people, as soon as the police have attended the address and there's been an accusation of he hit me, there's no injury. I mean, and the allegation is you pulled the hair, and there's no hair, there's no evidence, but there's been unlawful application, which is injury is not required. Actual bodily harm, just topping up on what Mr. Berman has said as well, black eyes, visible injuries, they will observe this as soon as they've come to the address. The police, this is where their investigation starts from. This is where they determine what allegation is being made. Is assault, but what level? Again, Mr. Berman, where he said more serious injuries, it could be a stab wound. It could be a deep, life-changing. There's other offences that we haven't really sort of touched upon, but something like threat to kill. I know in Bangladeshi culture, amra khuda dewa shizu sundor lage, but ultimately, it's the effect on the person who is being subject to that threat to kill. And threat to kill is a very serious allegation, especially how it's been perceived as well. Threat to kill, I mean, you're looking at a Crown Court matter up to about 10 years imprisonment for making a threat to kill. So it's very it does get serious. Another one I just want to touch upon is strangling. I know there's a lot of sort of strangling people, restricting breathing. This is a very serious one as well. So I mean, there's a lot of offences, but unlawful physical violence on someone, it could be verbal, it can be, if it's not common assault, it might be a threat to kill. If it's not visible injury, you can strangle someone and not leave any injuries. So it's very important. It's what's been alleged, it's what's been said against you.
Okay. Would you like to add
Yes, thank you for that. Basically, they cover everything. I just want to add something. Assault, আমরা বাংলাতে যেটা বুঝি সহজ ভাষায় এটা অত্যাচার। অত্যাচারের অনেক মাত্রা আছে, যেমন যেটা ওনারা বললো যে অ্যাসল্ট ক্লাসিফিকেশন, অ্যাসল্ট হইতে পারে ফিজিক্যাল বডিলি হার্ম, অ্যাসল্ট হইতে পারে বাট্রি, অ্যাসল্ট হইতে পারে অ্যাকচুয়াল বডিলি হার্ম। সবচেয়ে লো লেভেলের যে একদম লো লেভেলের যে অ্যাসল্টটা সেকশন 39 মনে হয় ক্রিমিনাল জাস্টিস অ্যাক্ট 1988 এর সেকশন 39 একটা অ্যাসল্ট আছে যেটা একদম ছোট লেভেলের অ্যাসল্ট, এটা অত্যাচার। তো এই যে বাট্রিগুলো এটা আনলফুল ফিজিক্যাল যেটা টাচ যেটা হয় এটা হলো বাট্রি, এটা আইনের ভাষায় বলে। আর যেটা আমি বলতে চাই যে আমাদের এখানে যে অ্যাসল্ট occasioning actually bodily harm, ABH যেটা এটা হইলো মোটামুটি এটা ব্রুজিং যদি হয়, আঘাত হয়, চিমটা যদি কেউ মারে অথবা ব্লিডিং একটু হয়, এটা একটা অ্যাসল্ট। এটা তারপরে বডিলি গ্রিভিয়াস বডলি হার্ম যেটা এটা অত্যন্ত সিরিয়াস, যেটা মনে করেন অনেক সময় ব্লিডিং হয়, অনেক সময় ফ্র্যাকচার হইতে পারে, তারপরে সিরিয়াস ব্রুজিং হইতে পারে। এগুলো অনেক ধরনের ক্লাসিফিকেশন আছে অ্যাসল্টের। তো অ্যাসল্ট প্রথমে যেটা বললাম যে অ্যাসল্ট হইতে পারে আপনার সোয়ারিং, এটা হইতে পারে পুশিং, হইতে পারে চিমটি মারা, অ্যাসল্ট হইতে পারে কন্ট্রোলিং, যেগুলো আমরা ডোমেস্টিক ভায়োলেন্সে অ্যাবিউজে বললাম। এই অ্যাসল্টটা আস্তে আস্তে যেমন গ্রিভিয়াস বডিলি হার্ম, বাট্রি, তারপরে এই অ্যাসল্টগুলো সবগুলো কিন্তু অ্যাসল্ট। তো আমাদের যে জিনিসটা আমি টোকা করতে চাই যে আমাদের উই হ্যাভ টু বি ভেরি কেয়ারফুল নাও ডেজ, বিকজ পুলিশের কাছে যে ওয়েবক্যাম থাকে এগুলো এভিডেন্স হিসাবে থাকে। আমরা যদিও ফ্যামিলিতে যে জিনিসটা আজকের টপিকগুলো আমাদের ফ্যামিলি ডোমেস্টিক অ্যাবিউজের অ্যাওয়ারনেসের জন্য আমি বলবো যে আমরা যাতে সচেতন হই। অনেক জিনিস আছে আমরা ইমোশনালি করি, এই জিনিসটা বি কেয়ারফুল থাকতে হবে যে অনেক সময় পুলিশ এই দেশে এখন যেগুলো আগে জানতাম না, যেমন আমি একটা এক্সাম্পল দিই বাংলাতে দর্শকদের জন্য, যে আমি আমার প্রথম লাইফে আমি পল্লী চিকিৎসক ছিলাম, তখন আমি পেনিসিলিন ইঞ্জেকশন দিতাম। পেনিসিলিন ইঞ্জেকশন অনেক দিতাম, মজা পাইতাম, ভাবতাম যে আমি তো ডাক্তার হয়ে গেছি। 1982 হবে, তখন পেনিসিলিন ইঞ্জেকশন একটু ডিস্টিল ওয়াটার মিশিয়ে ইঞ্জেকশন দিতাম। তারপরে যখন পড়লাম যে একটু পড়তে থাকলাম, তখন দেখা যায় যে পেনিসিলিন যদি অ্যানাফাইলেটিক শক হয়, মানে একটা রোগীর ডেথ হইতে পারে, একটা রিয়াকশন হইতে। তখন যেদিন পড়ছিলাম আমি আজ পর্যন্ত আর ইঞ্জেকশন দিই। তার মানে আই লার্ন এ লেসন যে যদি আমি জানি জিনিসটা কী হবে তাহলে এই জিনিসটা আমি করতাম না, এটা আমি এক্সাম্পল। সুতরাং আমাদেরকে অত্যন্ত সচেতন হইতে হবে যে অ্যাসল্ট মানে যে কোনো কিছু অ্যাসল্ট হইতে পারে। পুলিশে যখন কেস নিয়ে নেবে তখন পুলিশের কেস অনেক সময় ছাড়ে না। এটি আমাদের মেসেজ টু অল দ্য ভিউয়ার্স। থ্যাংক ইউ।
What about property damage during an argument? Is that capable of becoming a criminal offence as well?
Yep. So, in terms of the number of different offences that can sit under the domestic setting, criminal damage is quite a popular type of case, particularly within a husband-wife, boyfriend-girlfriend scenario. Example: husband or boyfriend or even female partner may decide to smash an item, break an item. If they are intentional or they're reckless as to whether an item is broken, that's the definition of criminal damage. So carrying out an act that would result in damage, something that doesn't belong to them, would amount to criminal damage. And it can be various different things. What we see regularly within a domestic setting is somebody picking up someone else's mobile phone and smashing it. Again, that would constitute criminal damage and would be an arrestable offence.
Oh, thank you. Is there anything you'd like to add about criminal damage?
I'm going to make a little joke about this because I think one of the points I wanted to touch upon was damaging property belonging to another. So if you get into an argument and you want to break something, break your own phone, don't break their phone. Because if it belongs to you, then that doesn't constitute
criminal damage. Right.
Criminal damage. It's your property.
Yes, we understand. In the heat of the moment, it could be quite difficult to control.
It'll be difficult to charge you with criminal damage for destroying property that belongs to you.
Very,
but make sure it belongs to you and
very
you're not sharing it with anyone.
Very interesting. And Sir, would you like to add something?
Okay, I want to add something. আমরা মানুষের ঘুষার বেশি, আমরা এশিয়ান মানুষের একটু ঘুষা বেশি থাকে। তো আমরা যে কোনো মানে সার্কামস্টেন্সের মধ্যে আমরা ঘুষা উঠে, তো ঘুষা উঠলে আমরা মনে করি যে আঘাত না হইলে আমরা জিনিস ভাঙি, জিনিস ভাঙলে কি আমরা ঘুষা মিঠে। তো এটা কিন্তু একটা অ্যাক্ট আছে, ক্রিমিনাল ড্যামেজ অ্যাক্ট 1971, এটা আন্ডার সেকশন one of the act a person commit a criminal damage if they destroy damaged property. আমি লাগালাগি হইলো আমি লাথি মেরে একটা উইন্ডো ভাঙিয়ে দিলাম অথবা তার ফোন ভাঙলাম তার গাড়ি ভাঙলাম এটা বড় এটা ক্রিমিনাল ড্যামেজ এই জন্য কিন্তু আবার এটা এই সেন্টেন্সিং গাইডলাইনটা অনেক হাই সুতরাং আমরা ঘুষা কইরা ভিকটিম হয়তো ভিকটিমে নামে এটা যদি আমরা জিনিসও ভাঙি এটাও খাই এটা একটা ক্রাইম হয় সুতরাং এটা থেকে আমরা সচেতন থাকতাম ধন্যবাদ
Okay, thank you. And we understand, we'll talk about that later on in the series, but the sentencing guidelines below 5,000, above 5,000, we'll go to that later. Now, the last criminal offence that's often related to domestic situations is harassment. Repeated calls and messages. When does that become harassment? Mr. Berlin, if you can just...
So, yeah, the police will, or the prosecution, if the case gets to the Crown Prosecution Service, will have certain guidelines. And to keep it as simple as possible, it's whether the behaviour was considered reasonable in all the circumstances and whether it could be considered excessive and unreasonable. It's normally defined as a course of conduct which amounts to harassment, alarm or distress. So a common sense view is often taken. If it's one or two calls, that's often seen as reasonable. If it's a flurry of several calls over a short space of time and then more calls again, it's clear that the victim will feel that they are being harassed and the offence will be made out. So the police take a reasonable view on this when assessing the strength and whether it matches the criteria for harassment.
Okay, thank you for that, and we understand that it's a repeated series of offence. We are quite short on time, so I'm going to just swim through. Now, coercive control. What do we mean by coercive or controlling behaviour, and why is it treated so seriously in law? Solomon, if you
I think I already touched up on this, so I'm not going to sort of elaborate on it too much, but intimidation, threats, financial control over restrictions, monitoring movements or communication, isolating someone from their, let's say for example, you're married and you don't want your wife to go to her brother's house or her sister's house or her mother's house. It's affecting the autonomy of someone. But one thing I want to say is, for the audience, is previously, I know in the old life, if there's a problem at home, the difference is now, this goes to court, either the Crown Court or the Magistrate Court. It's the state is involved. It's not you call up your elders and they're going to have the world is adapting, and we need to adapt to because we're all living in sort of changing times. It's what it was once upon a time. It's not anymore. So you have to understand that things are changing, but that doesn't mean that there's anything wrong with how it's been done before or how it's done now. No one is trying to undermine anyone's authority by saying we're going to the court instead of to our elders or something. Everything is context. When it's domestic, it's all context.
Okay, thank you for that. So we are approaching the end, almost the end of our program, and we have a lot to cover. So perhaps we could continue this on our next session. But let's just before we end, what happens after someone is taken into police custody? Very shortly, if you could.
Yeah. So very briefly, the process would be that they be brought before the sergeant in the police station after having been detained by police. The investigating officer will outline the allegation, the reason they've been brought into custody, and it'll be the sergeant's decision as to whether they should be detained. If the sergeant feels there's insufficient evidence at that point, he will authorise a de-arrest. But assuming the sergeant is satisfied there's sufficient information at that time, he'll authorise detention and they'll be interviewed regarding the offence.
Thank you. We have very briefly spoken about bail conditions and the importance of that, and the importance of breaching bail when one is asked or told not to attend a certain place or communicate with a certain person. So just want to elaborate a little bit on that. Can someone be prevented from returning home or contacting another person? And if yes, what are the conditions usually that follow? Very briefly, please.
In a domestic setting, almost 90% of the time, there's conditions: don't contact the party while the investigation is going. It's usually for about a period of 3 months. In the meantime, they can exclude you from the family home, and you would have to arrange alternative accommodation. There's certain outcomes at the police station. What's important is, if you're arrested, I appreciate that arrest is not a proof of guilt. And whilst you're at the police station, available to you 24 hours a day, 7 days a week, you can consult with a solicitor. And it's very important, because if you are in that situation, contact Lord and Solomon. We are available. We can provide you with legal advice as to what happens after the police station. Because certain times you go to the police station, they release you on no further action. But then still there's what we call a domestic DVPN, violent protection order, which does in fact restrict you from returning to the family home, just to give you that space of time. And if you're in breach of that, then potentially it's another offence. There's possible outcomes at the police stations. With domestic, no further action is not the end. There's always something more.
Okay. And now, just before we end the show, in your experience, if you could all just give me a few remarks on the biggest mistakes people often make, and the advice that you would give them, very shortly, starting with you, Mr.
So very, very briefly, I would say they don't have to do it alone. There's no reason why they should have to go through the interview process without a solicitor present. It's imperative to have a solicitor with you, but more so, calling a solicitor means that there is a buffer between a suspect and the police. It gives them time to give formal instructions, and a solicitor can then assess the evidence and advise how they conduct themselves in interview. And don't forget, as I always say, once you're in the interview setting, anything that comes out of your mouth is evidence. You can't take it back. So it's imperative that the words you choose to use are carefully thought out and not done emotionally without thinking properly.
Thank you. And you said
Thank you. Yes, few words is for the viewers. প্রত্যেক দেশের মধ্যে, প্রত্যেক স্টেটের মাঝে সেট করা থাকে কে কোনটা ডিল করবো। আমাদের যে ক্রিমিনাল অফেন্সগুলো, ক্রিমিনাল যে ম্যাটারগুলো, যেমন হ্যারাসমেন্ট, অ্যাসল্ট অথবা যে ডোমেস্টিক ভায়োলেন্স, এগুলো নেগোসিয়েশনের ব্যাপার না। এগুলো হইলো ক্রাইম, যে কোনো দেশের স্টেটে এটা সেট আপ করে কীভাবে ডিল করতে হয়, এগুলো ক্রিমিনাল অ্যাক্টিভিটিস, এগুলো মীমাংসা করার বিষয় নয়। সুতরাং আমি রিমাইন্ড মি দ্যাট আমাদের সব বিচার আদালত হয়। আমরা স্পেশালি ফ্রম আওয়ার বাঙালি কমিউনিটি ইন বাংলাদেশ অ্যান্ড ইভেন হিয়ার, কোনো একটা ক্রিমিনাল অ্যাক্টিভিটিস হইলে কিছু মানুষের নেগোসিয়েট করতে হয়। নেগোসিয়েট অনলি ডেল্ট উইথ দ্য সিভিল ম্যাটার। যেমন বাংলাদেশও ভিলেজও অনেক সময় বিচার পঞ্চায়েত হয়, এগুলো অ্যালাউড নাই, কোনো দেশে অ্যালাউড নাই। কিন্তু এগুলো আবার অনেক সময় এটাতে অ্যাক্সেলারেট করে এবং অনেক সময় মানুষের ইনভলভমেন্ট হইয়া আরও বাড়াই দেয়। সুতরাং অ্যাসল্ট যেটা, যে অ্যাসল্ট এটা সেট আপ করা হয়েছে, অ্যাসল্ট একটা অ্যাসল্ট না, এটা কী বলে, হ্যারাসমেন্ট একটা অ্যাক্ট আছে যেটা 1997 হ্যারাসমেন্টটা হইতে পারে স্টকিং করা, ফলোইং করা, হইতে পারে আরও অনেক কিছু। যাই কাছে সময় শর্ট, I'll pass it to him. Thank you.
Very quickly, there exists no benefit under law in admitting guilt at the police interview. Absolutely none. Stay silent won't cost you any sentence and discount at the police station. You don't get credit for a guilty plea at the police station.
We'll see you next time, and we'll top up on a few of the offences we've mentioned today and several other topics. Thank you for joining us, and we'll see you soon.
Thank you.